In this
Well,
country,
in the 11th century, sorry, you want the short version of my grandparents are Armenian.
Welcome to our Bashful Law Immigration Minutes podcast, where we focus on giving you tips to navigate complex U.S. immigration laws without the politics. Bridging your employment visa status in the United States. Welcome, social media, family, and friends. Thanks for listening to another episode today of Just Wait One U.S. Immigration Minute. Our feature today is captioned the fire-breathing HR Dragon. Have you or someone you've known ever dealt with hostility or fear of one's own human resource HR department or representative? Specifically, if you hold non-immigrant work visa status and you have questions for HR about the progress of your work visa, you're met with either being ghosted or what appears to be a fire-breathing dragon HR personnel who is angry and annoyed at your questioning. And so you cower and just hope all is well with an extension or change of your work visa status being processed by your employer. Unfortunately, over the past 25 years, myself and our team of immigration lawyers have represented way too many clients in this situation. We are hired to then intervene when communication breaks down with one's employer or the employer's lawyer. Expectedly, foreign national employees are panicked about possible loss of status in the United States, and our lawyers successfully calm fears and cordially repair the employer and employee relationship while ensuring the integrity of the process and timely filing of the employee's non-immigrant visa status. Typically, our clients are the following: L visa and H-1B visa holders, F-1 students, international students holding CPT or OPT, and J-1 visa holders, to name a few. A scenario typically arises where the client employee status is soon to be expired and they have yet to receive a receipt notice from U.S. Citizenship and Immigration Services, also called USCIS, or have not received word from the employer's U.S. immigration lawyer that all is well, meaning that your status has been successfully bridged and or extended. Over the past 25 years, our lawyers have worked with employers and employees. Thank goodness most U.S. employers have empathetic HR departments. However, in the event one is unable to verify their timely processing of his or her own work visa status, I have 4 important tips that will solve this situation and make you feel more in control. Number 1, ask for a G-28 entry of appearance form. Your employer most likely has agreed to pay attorney fees to change or extend your status in the United States. However, it is important to ask for a copy of a G-28 entry of appearance form from the immigration lawyer that shows he or she is specifically representing you as well, and not just the employer. This is called dual representation. If you cannot access a copy of a G-28 entry of appearance with USCIS on your behalf, then your interest is not being represented, only that of the employer. Number 2, request a consultation with a lawyer of your choice, independent of the company's lawyer. You may hire an immigration lawyer for either a detailed consultation to review your file and provide a second opinion, or you may opt to hire your own immigration counsel to represent you through the entire process and coordinate with your employer's attorney. Number 3, always keep abreast and a copy of your legal file. Be aware through immigration counsel of all the steps and paperwork affiliated with maintaining or changing status with the U.S. government. For instance, in the case of an H-1B visa, you would ask your employer's attorney for a copy of the LCA, the I-129, HSUP, company support letter, and cover letter. This is not an all-inclusive list, but an example. You also ask for a timeline of when the major steps such as LCA will be completed and ultimately when the application will be filed with USCIS or USCIS. Finally, number 4, if you are asked to return to your home country by your employer due to error by an immigration lawyer or the Human Resource Department, stop and retain your own U.S. immigration counsel immediately before taking any action. Well, if you keep those tips in mind, you can assure yourself peace of mind and see the red flags indicating it is time to seek your own independent immigration counsel. We understand you've worked hard to be eligible for your U.S. employment visa, and the cost of an error or misstep is too high. When an individual's non-immigrant status is not handled diligently, heartache and significant loss is avoidable for the employee and his or her family. So take courage and do not fear a fire-breathing dragon, especially when it comes to bridging your status in the United States. Thank you for listening to this episode of Just Wait One U.S. Immigration Minute. You may contact our law firm at the contact information listed below for your convenience. We are standing by, and take care until next time. Thank you.